So the Texas Suppressor Freedom case, which aims to stop the NFA and ATF's regulation of suppressors, just got a second life. So let's talk about what just happened in this case. But really quick before we jump into this video, if you think the NFA and GCA need to be done away with, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. You can get dedicated roasts for organizations like FBC and GOA, so if you want great coffee and you want to support the 2A cause, check them out using the links down below, and if you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, in this video, I have an important update in a case that a lot of you guys have been asking me about. In this video, we're going to be talking about the Texas Suppress and Freedom lawsuit, which essentially aims to eliminate the NFA and ATF's regulations of suppressors in Texas. The case we're going to be breaking down and talking about in this video is called Paxton v. Richardson. This is an important and interesting case that was decided by a district court judge in July on cross motions for summary judgment. In July, the federal district court judge there issued an order granting the ATF's motion for a summary judgment, which essentially dismissed the case in its entirety for a lack of standing. To me, that opinion read as a big cop-out by that federal judge, which is usually the case when a decision is focused primarily on standing. And in that decision, the court ruled that none of the individual plaintiffs have an injury in fact to meet the standing requirement for the lawsuit. And also the court found that Texas as a state cannot stand in the place of their residents to sue the government and the ATF because of the application of the NFA towards those made in Texas suppressors. Now, after that case was dismissed in favor of the ATF, the case essentially sat quiet for a really long time, and it was unclear what the state of Texas was going to do, if they were going to move forward with the case, if they were going to continue to challenge the case, and if they were going to file an appeal. Well, I can now let you guys know, and all those people in Texas who ask me about this quite frequently, what's going on in this case. The state of Texas has filed an appeal. They've appealed that district court decision, and now this case is going to the Fifth Circuit Court of Appeals, who is going to review the whole Made in Texas Suppressor Freedom case and decide if a state like Texas can in fact put in place this type of law, which greatly limits the ability of the ATF and federal agencies to enforce the NFA and GCA's restrictions on suppressors. Now, for those not aware, this lawsuit arises out of Texas House Bill 957, which was passed just a couple years back. HB 957 aimed to exempt from federal regulation all suppressors that are made in and also remain within the state of Texas. HB 957 exempted silencers which are manufactured in Texas and which also remain in Texas from those federal firearms laws and regulations, including the federal registration requirements under the NFA. It also applied to the taxation requirements of the NFA, so it was a way to get around those federal requirements. The claim behind the law is that since these items are made and sold exclusively within the state of Texas, they do not fall under interstate commerce, and therefore they fall outside the purview of federal regulation by the ATF. After Texas passed this law, the ATF then sent out a warning letter essentially threatening to enforce the NFA and GCA's regulations against made in Texas suppressors, anyone who made them, sold them, or engaged in this type of conduct. Texas, along with individual plaintiffs, then filed a lawsuit against the government. This case was then submitted to a federal court on cross motions for summary judgment. Well, after reviewing the case, the district court then granted a motion for summary judgment in favor of the government and dismissed the case in its entirety. The court ruled in favor of the government under the rationale that the plaintiffs lack standing to bring the lawsuit. Under the concept of standing, legal actions cannot be brought simply on the ground that an individual or group is displeased with a government action or law. Federal courts only have constitutional authority to resolve actual disputes. Now, to show something like standing, there are three basic requirements. First, there must be concrete injury in fact that is not conjectural or hypothetical. Second, there must be causation, which is essentially some sort of fairly traceable connection between the plaintiff's injury and then also the complained about injury, something that connects the defendant, potentially the government here, to the plaintiffs that are challenging that type of injury. Third, there must be redressability, a likelihood that the requested relief, which is granted by the court, can in fact redress and cure that injury. Without standing, a legal action cannot proceed forward. And it's this concept of standing that the district court judge used to dismiss the case in favor of the ATF. Now, in this decision, the judge stated that the parties only contest whether plaintiffs have suffered an injury in fact. On review, the judge found that they had not suffered an injury in fact and therefore have no standing. The judge stated that individual plaintiffs are correct that the government has a history of prosecuting the illegal possession of unregistered silencers, but these plaintiffs have adduced no evidence that they in fact possess any illegal silencers or otherwise attempted any prohibited conduct, nor have they shown that they have been threatened with prosecution or that it is likely. And our doctrines of criminal law forbid convicting persons for mere thoughts, desires, or motives. Individual plaintiffs therefore failed to allege a substantial risk of prosecution based solely on the desire to do something the government has prosecuted in the past. So individual plaintiffs' fear of prosecution is imaginary or speculative at best and insufficient for Article 3 standing. So here the judge is essentially stating that the individual plaintiffs would have to allege that they possess an illegal silencer, or they have engaged in some sort of prohibited conduct, or they have gone through the process to try to register these items with the ATF. The court also claims that the plaintiffs could show standing through evidence that they have been directly threatened by the ATF in regard to their homemade Texas suppressors. Instead, what you would need is a plaintiff, I guess in this situation, who wants to fall on the sword for everybody and engage in the conduct that is deemed illegal so that they would have standing to sue the government. We have recently seen multiple judges try to cop out on this type of standing issue. For example, originally in the CCW, the CCIA cases out of New York, in the Antonyuk case, the judge there, the district court judge, raised concerns about standing and then denied some injunctions. Now, in that case, eventually the judge positioned the case and it was kind of remedied and the case was allowed to proceed forward, but standing is often used by judges when they don't really want to address a case. Now, the district court here in this Texas case also stated in his opinion that alleging that the law is unconstitutional and impacts Second Amendment rights is not enough to remove the burden of establishing standing. The judge stated that individual plaintiffs have not attempted to apply to make or register a silencer, and assuming that they are correct about the unconstitutional nature of the requirements, it is immaterial whether an application is ultimately approved or denied. Either an application is wrongfully denied and a plaintiff is injured because the government has deprived them of a silencer, or an application is approved and a plaintiff is injured by being subject to the process and tax. But individual plaintiffs' intent by itself to make a silencer in violation of these requirements fails to establish that they have been concretely injured by the process they seek to challenge. Again, the judge is positioning the case as if a person must go through the homemade suppressor process, go through the application with the ATF. Either they're approved or denied, and then they can bring a challenge either way. But essentially, they have to subject them to potential serious criminal prosecution because, again, they're probably doing something that the ATF would find very illegal. And based on all that, the judge granted the government's motion for summary judgment and dismissed the case in its entirety in favor of the ATF and the government. Now, that decision came out in late July, I believe, and that was really the last time we talked about this case on the channel. And almost every single day I get comments from people asking about the Texas Suppressor Freedom case, what's going on, but the case really had sat silent for a while, so there was nothing I can really tell you guys. But finally, we got some good news that I can share with you all, and for those of you in Texas, you're probably going to be very excited to hear this. The state of Texas has filed an appeal up to the 5th Circuit. That means that the 5th Circuit Court of Appeals will now review this Texas Suppressor Freedom case. Since this case was decided on a motion for summary judgment and on a basis of a lack of standing, the 5th Circuit can review on a few different things. Probably what they will try to do is try to limit it to whether or not the plaintiffs here, the Texas and the individual plaintiffs, have standing, whether or not the lower court was correct or not in dismissing the case. But since this is also a final merits decision, they could review this case in its entirety if they wanted. As many of you likely know by now, the 5th Circuit Court of Appeals has been very favorable when it comes to these administrative lawsuits, these agency lawsuits against the ATF, and also Second Amendment cases. They've ruled in our favor in multiple cases like the Vanderstock ATF Frames and Receivers case, the Mock v. Garland ATF Pistol Brace case, the Cargill Bump Stock case, and even the Supreme Court case that was recently heard in front of the Supreme Court, the Rahimi case. All of those came out of the 5th Circuit and they have been very positive decisions. The appeal to the suppressor case can set the stage for some sort of significant win that may actually strike a major blow to the NFA and GCA's application and restrictions on suppressors. So it's going to be very interesting now that this is appealed up to the 5th Circuit to see what they want to do. So definitely an important case, an important appeal going forward. I know a lot of Texas viewers here on the channel were wondering about this case, wanted to know what was going on. That's the update in this case. But as we get more information, I will let you all know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Also, want to mention that you might just want to double check your subscription feed because people comment all the time that they've been unsubscribed by YouTube, so just double check that. And then also, if you've watched the channel for a while and you're not subscribed to the channel, please consider subscribing to the channel. About 60% of all viewers aren't subscribed to the channel, so subscribe, help us to grow. So thank you guys so much for all of your support. But never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.